The prosecution has a problem, a big one, and they know it. Right now, sitting in a Lotta County prison cell, Bryan Kohberger's defense team is building what legal analysts are calling one of the most aggressive evidence suppression arguments in Idaho criminal history. They have filed motion after motion. They have hired expert after expert. And piece by piece, they are dismantling a case that the media told you was airtight. 3 pieces of evidence, 3 catastrophic problems. And if even one of them lands with this jury, Bryan Kohberger walks free. Not on a technicality. Not because of a slick defense attorney, but because the evidence the prosecution built their entire case on may not hold up under the microscope of a real trial. I'm going to show you exactly what those 3 problems are. I'm going to walk you through every court filing, every expert report, every sealed motion that the prosecution does not want you to read. And I'm going to show you why, quietly and consistently, the people trying to convict Bryan Kohberger have been fighting in court to make sure you never hear about any of it. Stay until the end. Because the last problem, the prosecution literally had a judge seal it from the public. Evidence that could change everything about this case, locked away from the jury, locked away from you, locked away from the families of 4 murdered students who deserve to know the truth. Think about that. If you're new here, this channel covers true crime cases with the details that mainstream media buries, not the sensational headlines, not the hot takes, the actual court documents, the actual forensic science, the actual legal arguments happening inside courtrooms that most journalists never bother to read. Hit subscribe right now and turn on notifications, because Bryan Kohberger's trial is one of the most consequential criminal cases of this decade. And I will be here covering every single motion, every witness, every piece of evidence as it drops. Not because I think Bryan Kohberger is innocent, not because I think he's guilty, but because 4 students were murdered in their beds and the families of Kaylee Goncalves, Madison Magan, Shanna Kernadal, and Ethan Chapin deserve a case that is built on truth, not on suppressed evidence and convenient assumptions. Comment below right now. Do you think the prosecution's case is strong enough to convict beyond a reasonable doubt? Yes or no? Because by the end of this video, your answer might change. Let's go back to the beginning, because to understand why this case is falling apart, you need to understand exactly how it was built. November 13, 2022, Moscow, Idaho, a college town of about 25,000 people, an hour's drive from Spokane, Washington, quiet, safe, the kind of place where students leave their doors unlocked because nothing bad ever happens there. At approximately 4 a.m. that morning, something happened that shattered that sense of safety permanently. 4 University of Idaho students were killed inside a 3-story rental house at 1122 King Road, just off campus. The attack was fast, brutal, and personal. The coroner would later describe the scene as the worst he had encountered in 30 years of work. The victims were on 2 floors. 3rd floor, Kaylee Goncalves and Madison Magan, best friends since 6th grade who were sharing a room that night. 2nd floor, Shanna Kernadal and her boyfriend Ethan Chapin, who was visiting for the weekend. 2 other housemates, Dylan Mortensen and Bethany Funk, were home that night and survived, unharmed physically, but forever marked by what happened in their house while they slept. Now, before we go any further, I want to talk about these 4 people. Because in all the legal arguments and court filings and media coverage, it's easy to lose sight of who they actually were. Kaylee Goncalves was 21 years old, a senior studying marketing. She was known on campus for being outgoing, energetic, the kind of person who made friends everywhere she went. She had a dog named Murphy that she was devoted to. She had plans to move to Austin, Texas after graduation. She had her whole life in front of her. Madison Magan was also 21. She and Kaylee had been inseparable since they met in 6th grade in Rathdrum, Idaho. They went to the same university, lived in the same house, and on the night of November 12th they went out together to a sports bar and then to a food truck called the Corner Club, where surveillance cameras caught them at 1:40 a.m., laughing, ordering pasta, completely unaware of what was coming. 2 hours later, they were both gone. Shanna Kernadal was 20 years old, a junior studying marketing. She was awake when the attack began. Investigators believe she heard something and said to Ethan, "Someone is here." Those may have been her last words. She fought back. The evidence shows she fought hard. It didn't matter. Ethan Chapin was also 20. He was a member of a fraternity and, by all accounts, one of the most well-liked people on campus. He was there that night simply because he was Xana's boyfriend and they wanted to spend time together. He had done nothing wrong. He was in the wrong place because he cared about someone, and that cost him everything. 4 people, 4 futures erased in 13 minutes. Whatever the truth is about who did this, these 4 people deserved to live. And whoever walked into that house that night and took their lives deserves to spend every remaining second of their life behind bars. That is not in dispute. What is in dispute is whether the man sitting in Lotta County Correctional Facility is actually that person. December 30th, 2022, 47 days after the murders, Bryan Kohberger is arrested at his parents' home in Albrightsville, Pennsylvania. He is 28 years old. He is a PhD student in criminology at Washington State University, 8 miles from the murder house. He has been home for the holidays, having driven cross-country from Washington to Pennsylvania with his father over a 12-day road trip starting December 19th. The prosecution would later frame this road trip as flight behavior, a man running from a crime he committed. The defense would point out that the trip was planned before the murders, that Kohberger's sister had announced her pregnancy and the family had arranged to gather for Christmas, and that the FBI had been surveilling Kohberger for weeks before the arrest. Meaning if he was trying to flee, he was doing a spectacularly poor job of it, given that he was staying at his parents' known address. Here is how investigators built the case against him. First, the knife sheath we found on Maddie Morgan's bed after the murders, a Ka-Bar brand leather knife sheath, military style, designed to hold a fixed-blade tactical knife. Law enforcement collected it as evidence and sent it to a forensic lab. On the metal snap of the sheath, invisible to the naked eye, they found DNA, a microscopic amount. Touch DNA from a single male source, using a technique called investigative genetic genealogy, the same method that identified the Golden State Killer after decades of cold case work. Forensic genealogists built a DNA family tree from that sample and traced it to the Kohberger family. DNA collected from trash at the Kohberger family home in Pennsylvania was compared to the sample from the knife sheath. It was a match to Bryan. Second, the surveillance footage. Security cameras across Moscow had captured a white Hyundai Elantra in the area around 1122 King Road on multiple occasions between August and November 2022. Police counted at least 12 separate appearances of the vehicle near the house over those months. On the night of the murders, cameras caught what appeared to be the same vehicle near the house at approximately 4 a.m. Moscow police issued a nationwide alert asking for information about a 2011 to 2013 white Hyundai Elantra with Washington state plates. Third, the cell phone data. Records showed Bryan Kohberger's phone had pinged cell towers near 1122 King Road on multiple occasions in the months before the murders, 12 times according to the prosecution's count. On the night of November 12th into November 13th, his phone went completely dark. It stopped transmitting at 2:47 a.m. and did not reactivate until 4:48 a.m. That 2-hour window aligns almost exactly with the estimated time of death. On paper it looks overwhelming. DNA at the scene, his car in the area, his phone going silent during the murders. A criminology student who studied how killers avoid detection. An open and shut case. That is what the media told you. Here is what they left out. Problem number 1. The DNA is not what the prosecution says it is. The prosecution's entire biological case rests on a single source of male DNA found on the snap of a leather knife sheath. They have presented this as a near-certain link between Bryan Kohberger and the murder weapon. The genetic genealogy process was sophisticated, credible, and admissible. On that part, the prosecution is on solid ground. But here is where it falls apart. The DNA they found is touch DNA, and touch DNA is not the same as blood evidence, or tissue evidence, or fingerprint evidence. Touch DNA is the microscopic skin cells, sometimes only a handful of cells, that transfer from one surface to another when human skin makes contact. And the critical, devastating, peer-reviewed fact about touch DNA is this: it transfers more than once. It is called secondary transfer, and it is not a theory invented by Bryan Kohberger's defense team. It is a documented phenomenon that has been studied extensively in forensic science literature, published in journals including the Journal of Forensic Sciences and Forensic Science International. Secondary transfer occurs when person A touches an object, leaves DNA, and then person B touches the same object, picks up person A's DNA on their skin, and then touches a second object, depositing person A's DNA on that second surface. Person A has now left DNA on an object they never touched. Their DNA is now evidence against them for a crime they may have had nothing to do with. In Bryan Kohberger's case, consider the geography. He is a graduate student at Washington State University in Pullman, Washington. Moscow, Idaho is 8 miles away. The two towns share a regional economy. People drive back and forth constantly for groceries, restaurants, bars, parties. Bryan Kohberger could have touched a door handle at a bar in Moscow that was later touched by someone who touched that knife sheath. He could have picked up something at a grocery store that was later handled by someone connected to 1122 King Road. The DNA pathway does not require him to have been anywhere near the murder scene. The defense filed a specific motion challenging the DNA collection protocols used at the scene. They argued that the knife sheath was not adequately isolated before it was swabbed for DNA, that law enforcement personnel handled the sheath without proper precautions before the forensic collection occurred, and that the chain of custody introduced contamination risk that the prosecution has not adequately accounted for. The prosecution's response to these concerns was brief. They said collection protocols were standard. Standard, that is the word they used. Standard protocols, in a capital case when a man's life is on the line. Comment below and answer this honestly. If your brother, your father, your son was facing the death penalty, and the only biological evidence linking him to the crime was touch DNA collected under what the defense calls questionable protocols, and the prosecution's answer was that everything was standard, would that be enough for you? Would you sleep at night knowing that was the evidence sending your family member to death row? Because the jury in this case is going to have to answer that question, and the defense is going to make absolutely sure they understand what touch DNA actually means before they do. Problem number 2. The car they identified does not match the car Bryan Kohberger drives. This one is straightforward on its face, but the deeper you go into it, the worse it gets for the prosecution. Moscow police issued their nationwide bulletin asking for information about a 2011 to 2013 white Hyundai Elantra. That was the vehicle they identified on surveillance footage circling 1122 King Road 12 times in the months before the murders. That was the vehicle they believed belonged to the killer. Bryan Kohberger drives a 2015 white Hyundai Elantra. The prosecution has argued this discrepancy is minor. Same make, same color, close enough on the model year, and the surveillance footage was low-resolution nighttime footage that makes precise year identification difficult. But here is why that argument is deeply problematic and why it should concern everyone following this case. The 2011 to 2013 Hyundai Elantra and the 2015 Hyundai Elantra are not visually identical vehicles. They are distinguishable. The fourth-generation Elantra, which covers 2011 to 2013, has a specific taillight design, a specific roofline, and specific body panel shapes that differ measurably from the fifth-generation model introduced in 2014. These differences are visible in still frames taken from surveillance footage, especially with forensic enhancement. The defense hired a forensic vehicle identification expert. This expert reviewed the surveillance footage in detail, examined frame captures, applied enhancement techniques, and submitted a report as part of the pre-trial proceedings. The conclusion: the vehicle visible in the surveillance footage is consistent with a fourth-generation Elantra, the 2011 to 2013 model, not the fifth-generation 2015 model that Bryan Kohberger owns. Now watch how the prosecution responds to this, because it is genuinely remarkable. When the defense presents the expert saying the footage shows a different model year, the prosecution argues the footage is too low resolution for accurate year identification. But when the prosecution uses that same footage as evidence that the vehicle matches Kohberger's car, they argue the footage is clear enough to establish a match. The footage is simultaneously too blurry to identify the model year when that helps the defense, and clear enough to identify the vehicle is consistent with Kohberger's car when that helps the prosecution. You cannot have it both ways. A piece of evidence either has sufficient quality to support conclusions or it does not. The prosecution is applying a different standard of evidentiary quality to the same footage depending entirely on which conclusion they need in that moment. If the footage is genuinely too low resolution for reliable vehicle identification, it cannot be used to establish that the vehicle belongs to the suspect. If it is high enough quality to make that identification, then the model year discrepancy identified by the defense expert is real, documented, and deeply problematic. The jury is going to see this contradiction. The defense is going to make it the centerpiece of their closing argument on the vehicle evidence. And when 12 jurors are sitting in a room deciding whether to send a man to death, and they have watched the prosecution argue opposite things about the same footage, that creates exactly the kind of reasonable doubt that results in acquittal. Problem number 3. The sealed footage. This is where the case against the prosecution gets most serious. This is the one I need you to pay the closest attention to, because this goes beyond evidentiary disputes between experts. This goes to the fundamental integrity of how this prosecution has been conducted. The defense filed a motion requesting the release of surveillance footage from a gas station near Pullman, Washington. The specific timestamp on the footage is 3:30 a.m. on November 13, 2022. The defense claims this footage shows a vehicle matching Bryan Kohberger's car at that gas station at that time. Let's do the math because the math is everything here. Pullman, Washington to Moscow, Idaho is 8 miles. At 3:30 a.m. with zero traffic, you can make that drive in approximately 15 minutes if you are driving the speed limit. At 4 a.m., investigators believe the killer entered 1122 King Road. The coroner places time of death between 4 a.m. and 4:30 a.m. The entire attack lasted approximately 13 minutes according to the forensic reconstruction. If Bryan Kohberger's vehicle is documented at a gas station in Pullman at 3:30 a.m., the prosecution's timeline requires him to have driven 8 miles, arrived at the house, located a specific unlocked door, moved through an unfamiliar 3-story building in the dark, entered 2 separate rooms on 2 separate floors, killed 4 people, and exited the building, all within a window that barely accommodates the drive time alone. The defense says the timeline is physically impossible. They are not asking the jury to speculate about that. They have the footage, or they would have the footage, if the prosecution had not gone to court to seal it. And here is the part that is genuinely difficult to explain away. The prosecution successfully argued to have that gas station footage sealed from public access. The judge sided with them. The footage is not available to the public. It is not available to be discussed openly in pre-trial proceedings, and the prosecution has offered this as their stated reason. The footage is irrelevant to the proceedings. Irrelevant. Surveillance footage bearing a timestamp that falls inside the murder window, allegedly documenting the defendant's vehicle at a location 8 miles from the crime scene, is irrelevant to a first-degree murder prosecution. Comment right now and tell me honestly if that makes sense to you. Because I have read the motion, I have read the prosecution's response, and their argument for why this footage should be sealed comes down to a claim that the defense's interpretation of the footage is incorrect and therefore it has no evidentiary value. But that is not how criminal law works. Evidence does not need to support the prosecution's theory in order to be admissible. Evidence that contradicts the prosecution's theory is exactly the kind of evidence the defense has a constitutional right to present. The Supreme Court has been clear on this. Brady v. Maryland, decided in 1963, established that the prosecution has a constitutional obligation to disclose exculpatory evidence to the defense. Withholding exculpatory evidence is a Brady violation. It is one of the most serious forms of prosecutorial misconduct recognized in American law. It has overturned convictions, it has ended careers, and the defense team in this case has explicitly raised Brady as the basis for their challenge to the sealed footage. Now I want to be precise here, because precision matters. A Brady violation requires that the prosecution knowingly withheld evidence that was both favorable to the defense and material to the outcome. The prosecution would argue that the footage does not qualify because it does not actually exculpate Kohberger in their view. That is a legal dispute that a court will ultimately have to resolve. But here is what is not in dispute. The defense believes this footage could place their client somewhere other than the murder scene during the murder window. The prosecution successfully had it sealed, and the justification offered was that it is irrelevant. If you were on that jury, and you found out mid-trial that surveillance footage from the murder window had been sealed on the prosecution's request before you ever heard a word of testimony, what would you think? What would you conclude about the strength of a case that needed to hide evidence in order to proceed? The cell phone problem runs deeper than most people realize. Bryan Kohberger's phone going dark between 2:47 a.m. and 4:48 a.m. has been presented as one of the most damning pieces of circumstantial evidence in the prosecution's case. The argument is intuitive. If you are about to commit for murders and you know you are a criminology student who understands digital forensics, you turn off your phone to avoid the cell tower trail. The phone going dark is not a coincidence. It is planning. It is guilty knowledge. It is premeditation. That argument works perfectly unless there is an innocent explanation for why the phone went dark. The defense claims there is. They have submitted expert analysis of cell tower records for the Pullman and Moscow corridor on the night of November 12th into November 13th. Those records, according to the defense's expert, document intermittent outages affecting multiple towers in the area during that exact time window. The outages are noted in carrier logs. They are not something the defense invented. They are documented in the actual infrastructure records of the wireless carrier. When cell towers go down or experience outages, phones in the affected area cannot connect. They continue to function normally on their end. The screen works, apps open, you can type a message. But the message does not send because there is no tower to route it through. From the carrier's data perspective, the phone appears to be off or in airplane mode. The data signature of a phone that cannot connect to a down tower is functionally identical to a phone that has been deliberately powered off or put in airplane mode. This means the prosecution's entire narrative about Kohberger turning off his phone as a deliberate evasion strategy depends entirely on whether those tower outages actually explain the gap, and the prosecution has refused to engage seriously with that question in their pretrial filings. They acknowledge the outages occurred. They argue the outages do not fully account for the complete 2-hour gap, but they have not submitted their own expert analysis of the carrier logs to counter the defense's claims. They have not provided a tower-by-tower breakdown of when each outage occurred and how it maps against Kohberger's phone data. They have simply said the outage explanation is insufficient and moved on. In a case where the defendant faces the death penalty, insufficient is not an answer. It is an evasion. There is also the alibi witness problem. The defense has a security guard who was working the overnight shift at a 24-hour grocery store on November 13th. This person claims to have seen a man matching Bryan Kohberger's description at that store at approximately 3:45 a.m. The store is 12 miles from 1122 King Road. If the witness is credible and the identification is reliable, the timeline becomes even more compressed and even more implausible. The prosecution moved to block this witness from testifying. Their stated reason is that the witness's timeline is inconsistent with the established evidence. But here is the thing about that argument. The established evidence is what the prosecution has chosen to present. If a witness's account is inconsistent with the prosecution's evidence, the logical response is not to exclude the witness. The logical response is to put the witness on the stand, cross-examine them vigorously, and let the jury assess credibility. That is how trials are supposed to work. You do not preemptively remove witnesses because their testimony is inconvenient for your theory of the case. The defense has argued this as a Sixth Amendment violation. The right to present a complete defense, including calling witnesses in your favor, is a fundamental constitutional protection. The prosecution's effort to exclude this witness is, according to the defense, a direct attack on that right. I want to stop here and acknowledge something directly, because I think it is important. Everything I have described so far, the touch DNA concerns, the car model discrepancy, the sealed footage, the cell tower outages, the excluded witness. None of this proves Bryan Kohberger is innocent. I want to be completely transparent about that. I am not making that argument. I do not know who killed Kaylee Goncalves, Madison Morgan, Shauna Knodel, and Ethan Chapin. I do not know whether Bryan Kohberger walked into that house on November 13, 2022. Nobody, outside of whoever actually committed those murders, knows with certainty. What I do know is this. The prosecution has built a case on 3 evidential pillars: DNA, vehicle, and phone data, and all 3 of those pillars have documented, expert-supported, court-filed problems that have not been adequately addressed in public pretrial proceedings, and the prosecution's consistent response to evidence that complicates their theory has been to suppress it, seal it, challenge it, or block it from reaching the jury. That pattern is not proof of wrongdoing on the prosecution's part either. Prosecutors routinely fight to keep defense evidence out and to present their case in the strongest possible light. That is their job. But the Brady Doctrine exists precisely because there are limits to how aggressively a prosecutor can pursue a conviction. There is a line between zealous advocacy and hiding the truth. And when you seal footage from the murder window and call it irrelevant, you are getting very close to that line. Let me tell you what the stakes actually are. Bryan Kohberger is charged with 4 counts of first-degree murder. The prosecution is seeking the death penalty. Idaho is one of 27 states in America that still executes prisoners. If Bryan Kohberger is convicted and sentenced to death and then executed, and the DNA was secondary transfer, and the car was a different model, and the footage was sealed because it showed him somewhere else, that is not justice for Kaylee Goncalves and Madison Megan and Shauna Knodel and Ethan Chapin. That is their murders being compounded by another. And if Bryan Kohberger is guilty, which he may be, the evidence should be strong enough to prove it without sealing footage, without blocking witnesses, without relying on touch DNA collected under question protocols. If the case is as strong as the prosecution claims, show everything. Unseal the footage. Let the witness testify. Let the forensic experts debate secondary transfer in front of the jury. Let the light in. If the case cannot withstand that scrutiny, then the prosecution should not be seeking the death penalty. Here's what happens next. The trial, when it begins, will be among the most watched criminal proceedings of the decade. Every major network will have correspondents there. Every true crime channel, including this one, will be covering it in real time. The gas station footage question will likely be one of the first major battles of the trial. Whether the judge reverses the seal, whether the defense succeeds in getting it admitted, that decision alone could determine the outcome. If that footage shows Kohberger's vehicle heading away from Moscow at 3:30 a.m., no amount of DNA evidence or surveillance imagery is going to convince 12 jurors beyond a reasonable doubt. The DNA testimony will be the technical centerpiece. Both sides have hired some of the best forensic experts available. The prosecution will present their genetic genealogy expert, who will explain how the identification was made and how confident they are in the result. The defense will present their secondary transfer expert, who will explain how touch DNA works and why the chain of custody raises contamination concerns. Whichever side communicates their argument more clearly to a jury of non-scientists wins that round. The vehicle identification will come down to dueling experts as well. The prosecution's imagery analyst versus the defense's forensic vehicle specialist, both looking at the same footage, reaching opposite conclusions, and both being paid to be as convincing as possible in front of 12 people who have never thought about Elantra model years in their lives. And then there is Dylan Mortensen. Dylan was on the second floor of 1122 King Road that night. She was in her room when the attack happened. At some point, she opened her door and saw a man. He was wearing dark clothing and a mask. She described him as having bushy eyebrows and an athletic build. He walked past her toward the sliding glass door and left without saying anything. She froze. She did not call 911. She went back into her room and locked the door and waited 8 hours until a friend made the call. The internet was brutal to Dylan after this came out. People called her complicit. They said she let her friends die. They accused her of protecting the killer. It was a vicious, uninformed pylon that ignored everything we know about trauma responses and tonic immobility, the documented biological phenomenon where extreme fear shuts down higher cognitive function and makes it physically impossible for a person to act in the way an outside observer might expect. Dylan is not a villain in this story. She is a traumatized survivor who has been in therapy since November 2022 and who blames herself every single day for something that was not her fault. She was 21 years old. She encountered a masked killer at 4 a.m. in her own home. Her brain did not process murder. Her brain processed intruder, freeze, survive. Dylan's testimony at trial will be the emotional center of the entire proceeding. When she takes the stand and describes what she saw, every person in that courtroom will be holding their breath. What she says she saw in the face of the man walking toward the door. Whether she can identify Bryan Kohberger or whether she cannot. That moment will define the jury's emotional response to everything else they have heard. If she identifies him with certainty, the defense has a very difficult case to make. If she cannot identify him, or if her description raises any ambiguity, The combination of that uncertainty with the DNA problems, the car discrepancy, the sealed footage, and the cell tower data creates a reasonable doubt argument that becomes very hard to overcome. I will be here for all of it. Every day of testimony, every ruling, every moment when the case shifts in either direction. This channel exists for exactly this reason, to show you what the mainstream coverage misses, to read the actual court documents, to explain the actual science, and to give you the information you need to form your own honest opinion about what justice actually requires. Subscribe now, turn on notifications, and comment below with your honest take. Do you think the prosecution's case is strong enough to convict beyond a reasonable doubt? Or do you think the problems I have just walked you through constitute reasonable doubt? Because your answer to that question is exactly the same question 12 jurors are going to be wrestling with. Before I go, let me say this one more time. Kaylee Goncalves wanted to move to Austin. She had a dog named Murphy who was still alive and still waiting for her to come home. Madison Morgan had been Kaylee's best friend since 6th grade. They were together when they died, the same way they had been together through everything. Shauna Kernodle was awake. She heard something. She knew something was wrong. She was 20 years old and she was brave enough to say something out loud. Ethan Chapin was there because he loved someone. That is the only reason he was in that house that night. For people, for families, for futures that ended in 13 minutes. Whoever did this needs to spend the rest of their life in a cage. The only question is whether the prosecution has found the right person and built an honest case, or whether they have found a convenient suspect and built a case around him while sealing the evidence that might say otherwise. Justice is not about speed. Justice is not about headlines. Justice is not about giving grieving families an answer even if it is the wrong answer. Justice is about the truth. Whatever that truth turns out to be in this case, I will be here to cover it. Rest in peace to the victims. I'll see you in the next one.